interim order, my lord. That may come, it was filed on 4th of May, may come on 15th, my lord.
We'll have it on 17th. 17th.
Right.
Yes, yes.
My lord, I beg to mention a repetition for listing on tomorrow, my lord.
Listing for what?
My lord, this is regarding the petitioner is presently working as assistant commandant CRPF.
Hmm.
Now in his,
Listing for what?
my lord, for motion, my lord.
And what order you on?
So, my lord, he is working as assistant commandant.
Hmm.
During his probation period, my lord, he has been detected, my lord, diabetes and hypertension. So he has been reverted to his earlier post.
You get it done, but it is permissible. That's
May-
the law.
Maybe please, your lordship.
But
I'd like to mention for listing of an item for admission, lordship.
After 15 June, any date you put.
Monday, lordship.
After 15th of June, you
15th
put any date, yes. What is the matter about?
matter about relative promotion.
15th of July. Yes.
May please, your lordship. I beg to mention item number 19 of today's list. I am praying for an adjournment, your lordship.
You are for the respondent.
Respondent bank, lordship.
No objection.
No.
With the consent of learned counsel for the opposite party, Mr. H. Boragohai, learned counsel appearing for the respondent seeks adjournment in this matter with a request to post the case for hearing again after 4 weeks. Prayer allowed, list accordingly.
May I please, your lordship.
Yes.
Lordship, I beg to mention one repetition for listing in admission. In this matter, I am appearing for the respondents and there is interim order, lordship.
What is the matter about?
Matter is about transfer, lordship, and transfer order is stayed by this honorable court. Matter may be taken on 17th of May.
17th of June. June. Why don't you file an application for stay vacating? Huh? You have urgency, so you file an application for stay vacating. We'll take up the matter. Yes. Next
May I
one.
please, your lordship. Lordship, I beg to mention for listing of an matter, repetition, your lordship, in hearing, your lordship, for hearing.
After 15th of June.
Oblige, your lordship.
My lord, item number eight, my lord. I have taken the consent of the petitioner, my lord. I apply for 1 week time, lord.
So 1 week time for what?
My lord, otherwise pleadings are ready. Lordship, for hearing of the matter, I need 1 week time, lord, for preparation.
Consent of learned counsel for the opposite party, Mr. B. Nath, learned additional senior government advisor, Assam, appearing for the official respondent. So if the government in the matter with the request to post this case for admission hearing again after 2 weeks. If the prayer is not opposed, same stands allowed, list accordingly.
Lordship, may I pray for a date, your lordship, in this matter?
Date will not be possible today, after 2 weeks. After 2 weeks.
May I please, your lordship? Lordship, I beg to mention for listing an I have, lordship, Monday. I have for lordship withdrawal of the name of the petitioner, lordship. One of the petitioner, lordship.
That, how can you file an IA like this? That is not permissible. All right, you get it.
Yes, oblige, lordship.
May please, your lordship. I beg to mention an item for listing, your lordship, for admission. To writ petition, your lordship,
Yes. After 15th June.
after 15. Much obliged, your lordship.
May I please, your lordship? Lordship, I beg to mention for listing of a case, lordship, matter relating to pension and benefit, lordship, plus 4 years, lordship, my pension and benefit yet to be released, lordship.
24th May.
Lordship, on 17th of June, my senior Mr. S.K. Medhi will be out of station. Matter may be taken on 13th of June. Oblige.
May it please, your lordship. With the consent of other side, I beg to mention item number 3, lordship. In this matter, my senior is not well today. He's not able to come today.
Item number?
Item number 3, your lordship. After a week.
There is no 1 week, always 2 weeks.
Oh, yes, your lordship.
Item 3, as paid for by learned counsel for the petitioner. Admission hearing of this matter stands adjourned for 2 weeks.
I'm obliged, your lordship.
May it please, your lordship. My lord, in this matter, subject to what my lord will, learned senior counsel Dr. Saraf is appearing, my lord. And I have been, my lord, requested.
No, you are upgrading stage by stage.
My
Last
lord,
date-
because my lord, certain issues are there. where they,
Your client has already opted for another,
my lord.
your client has already opted for deputation in another.
But my lord, my right to this is called, my lord, parallel transfer, your lordship, that I have enclosed notification of others in my reply to IA, your lordship. And ED has given certain, my
Just
lord,
1 minute. Your client is now working where?
he is additional director general in Competition Commission of India.
All right. So he cannot be removed from there unless Competition Commission gives the approval. Supposing today the court holds that your client was entitled to go on deputation. This order cannot be complied with unless the Competition Commission gives
It
no.
is in
NOC.
same department, Ministry of Finance, my lord. And if the case before your lordship, it is wrongly projected, this is not the case. Case
Well,
is,
then you argue, we'll hear it.
my lord, because my lord client has engaged, that's why I'm praying. If your lordship will not, then in that case, my lord, I
This
will.
matter was fixed today.
Today, my lord. Otherwise, I'm ready. I have prepared list of dates, everything, my lord. But since senior counsel is there, my lord, and he will apprise your lordship in better way than me, your lordship.
That's all right. That's another matter, but
My-
we get.
Because of
matter
that,
listed and-
otherwise, my lord, if your lordship insisted, then I have prepared everything, my lord. And case, the affidavit filed by them, my lord, wrong statement has been given in the
My
affidavit.
lord, our position is that well, from since 2020, that the post has been vacant, my lord, due to my lord interim
All right,
order.
then we wait for another 2-3 days. Let,
2-3 days. my- yes,
no
that was-
adjournment on the next day.
Yes,
my
sir,
16th.
2-3 days. yes.
My lord.
On the prayer of Mr. A. Goel, learned counsel for the writ petitioner OP, this matter is directed to be posted again on 16th of May.
On
2023
16th, my lord.
As a fixed item, Ms. A. Gayan Leonard CGC is present on behalf of the applicant. It is made clear that in view of the urgency expressed by the applicant's counsel, no prayer for adjournment will be entertained on the next day.
On 16th, my lord.
Yes.
16th,
Master
my
bless.
lord. Deeply obliged.
May it please your lordship. This matter your lordship has earlier heard. And on the last occasion, your lordship asked me to refresh it a little bit. This matter, your lordship, I have already given a list of dates. And from there, it will be easier for your lordship to appreciate the case. Kindly, your lordship will kindly take up the list of dates first. This matter basically. Mr. Maran, just 2 minutes. Please take your seat. I'll. All right, yes. Your Lordship. This matter basically was, we challenged the enhancement of the punishment of the petitioner. And this was done without the following due procedure as per the CRPF rules. Though notice was given, but that was procedure has specifically prescribed certain procedure that was not followed. This is number one. Second, the enhancement was of the punishment for a crime which has not been committed. There was no crime committed in the present case. Even the inquiry did not find any crime committed. Only the issue was that the person has visited, is basically a person who visits the particular person's house without being invited. He is an uninvited guest, because of which there was a punishment given. So the punishment of retirement, compulsory retirement, is excessive, very excessive. This is basically the whole matter. So your Lordship, I'll take your Lordship to the matter. If your Lordship take up the list of dates, that will be easier for. An FIR was lodged, your Lordship. List of dates is there.
List of dates, part of your petition.
Yeah, no, I have already provided that. It
That's
is
what-
there. I have in fact seen it. I've seen the file in the morning. It is there.
Take it back.
Second copy to থাকিব পাৰিবি মই দেখা যেন লাগে second copy to চাই ল'বচোন
Yes.
Yes. In fact, your Lordship, an FIR was lodged by one Ranjit Roy, your Lordship, Borua, against the petitioner, which was registered as Nalbari PS under section 420. Case number 420 under section 384 and 34 of the IPC, your Lordship. And thereafter, your Lordship, this part I'll come later on. Thereafter, your Lordship, the petitioner was suspended from service. And on 27/10/2008, your Lordship, a notice on proposed inquiry was on 3 allegations were there. I will take your Lordship from here. Kindly, your Lordship will take page 25. I am bringing, there are 3 allegations against the petitioner. The notice is of 27 October 2008, page 25, annexure 2. Lordship will turn to page 27 for the allegations. Page 27 is the allegations, your Lordship.
Yes.
27 is the allegation, page 27. So there are 3 allegations basically. I'll read allegation, all the 3 allegations, your Lordship. All the 3 allegations are basically connected to each other. So allegation 1, as per rule 11(1) of the CRPF rules, the force number so and so and force number have been found guilty. Lordship, before that, I would like to point out there are 2 persons here, but only 1 petitioner before your Lordship have been found guilty of disobeying and neglecting the orders by following rules on not following rules on so and so hours when they forcefully demanded money from Ranjit Roy Borua, Assistant Engineer, Nalbari Water Resource Department at his residence, and subsequently being arrested by Superintendent of Police Nalbari. Allegation 2, it has been alleged that being the responsible member of CRPF force number so and so, disrespect their duty as per rule 11(1) of the CRPF rule 1949 by disobeying office orders and thus brought bad repute to the institution. And number 3, it is alleged that force number so and so had misused their duty being a responsible member of CRPF by violating rule 11 of rule so and so by means of misusing the government vehicle motorcycle registration number so and so and so and so. So these are the 3 allegations. First allegations, I have demanded money. Second, I have not followed orders. And third is that I am misusing the vehicle. All the 3 allegations are not proved. That is where your Lordship will kindly take up the inquiry report at page 43. I'll not read the whole inquiry report because it's a long inquiry report. I'll just read the decisions that the inquiry officer has come in all these 3 allegations. So first, your Lordship will find, the first one your Lordship will find at page 47, the allegation.
First allegation with regard to demand of money.
Yes.
That allegation, your lordship will find at page 47, the last Roman 4. Analysis and assessment of the statement and document. With the help of the witness of the complainant so-and-so, Superintendent of Police Nalbari so-and-so, 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 the complainant filed an FIR against the two accused. The officer in charge of Nalbari Police Station sent a wireless message to the officer of the commandant so-and-so battalion in this regard on 15/9. The office of the commandant battalion sent a detailed report to the higher authority on so-and-so. All this communication establishes the fact that the two accused had committed the said crime and caught red-handed. But at the time of arrest, neither any weapon nor money has been recovered from the accused. The fact that the accused demanded the extortion money could not be established. So the first point, that there was no establishment of demand of money. The report is there, Roman 5. The final report and verdict of the inquiry officer on the allegations. Considering all aspects, the inquiry officer comes to the conclusion that both the accused went to the residence of so-and-so and subsequently got arrested. But the fact that they forcefully demanded the money cannot be established. Therefore, allegation 1 leveled against the two accused is partly proved. It is actually not proved. They have stated partly proved, but it has not been proved. Anyway, so now your lordship will kindly come to the second allegation at page 49. Analysis and assessment of the statement and documents. Roman 4, last paragraph. With the help of the statement of witness of so-and-so and Nalbari police so-and-so, etc., inquiry officer have come to the conclusion that both the accused went to the house of Ranjit Roy Boria, and while discussing about extortion of money, the superintendent police caught them red-handed. This act has brought bad repute to the CRPF, which is very disciplined force. Therefore, allegation 2 has been found to be true and proved. Now the question, these two are contradictory to each other, because the earlier he said that it has not been proved, there was no demand of money. But here he says that it is the act has brought bad repute to the CRPF. He could have said that he has went into the house of so-and-so, because of that it is a bad repute. But he has said the demand of money, but demand of money is not proved at all. Now your lordship, the third allegation. That allegation your lordship will find at page 51. Last paragraph, Roman 4. Analysis and assessment of the statement and documents. Again, the same persons have given the statement. As per reply given by so-and-so, Nalbari police witness in the case, their motorcycle bearing registration number was found at the residence of Ranjit Rai Boro, which was later seized by the investigating officer. When I inquired the whole incident, it has been found that the motorcycle was in the custody of CRPF by virtue of their request letter to the Assam police. The accused got it from transport officer, Nalbari on so-and-so. This proved the fact that on so-and-so the accused misused the vehicle by using it for non-official purpose for an offense. The matter of misuse of the Maruti Gypsy by the accused on so-and-so, as stated in the witness statement, was not based on evidence. From the inquiry, it was found that they used the vehicle on 9/9/2008 for official purpose only. Therefore, it is substantiated that they actually it is not misused the Maruti Gypsy. It should be not misused. Then a final report, your lordship. The final report and verdict of the inquiry officer on the allegations. Considering all aspects, the inquiry officer come to the conclusion that accused Havildar Narendra Singh. So Narendra Singh is before your lordship, and Constable Ram Bilkas Rai is not before your lordship. Misused their power as government servant and used the motorcycle bearing registration number is proved, but the allegations on the accused that they misused the Maruti Gypsy bearing so-and-so is not true, as there is no proof from the statement of so-and-so. Therefore, the allegation of force number so-and-so and so-and-so of misusing the official motorcycle is in para 3 has been partially proved. So that is also partially proved. The Maruti Gypsy was not used. The motorcycle was found. It was partially proved on that point. These are the allegations. So the main allegation of taking money or extortion is not proved. The only allegation that is proved is that his motorcycle was found in the residence of the official motorcycle was found. That is the only proof. The Maruti was never used. That was also not misused. So under these circumstances, your lordship, what has happened? The commandant has imposed the punishment of reduction of that your lordship will see on 15/7/2009 in the list of dates. 15/7/2009, order of the commandant 136 battalion imposing the punishment of reduction of time scale of pay for 2 years and payment of basic salary during the suspension period from so-and-so to so-and-so with regard to the petition. This was the initial punishment given. We are not against this punishment. We are not even challenging this. Now what has happened? Next, your
What
lordship,
what is the page number of this document?
this document could not be annexed, your lordship. The order of the commandant, initial order could not be annexed. The record is there. Record is it on record. It could not be annexed because that was not provided to us at that time. So, but the punishment order has been quoted in the next letter that I will show you, lordship. That your lordship will find at page 64. Your lordship will see. This is a show cause notice by the Deputy Inspector General of Police on 24th of August 2009, your lordship. I'll not read everything. Lordship will kindly turn to page 65, part 3. And serial number 2. Part 3, serial number 2. This is the point which is before your lordship. As per the above allegations, I have already read the allegations, so I am not reading the earlier part. Departmental inquiry was done, and after that, the commandant so-and-so, through office order dated 15/7/2009. This is the 15/7/2009 order. And as per CRPF rule number so-and-so, the following punishment has been declared. A, the basic pay of force number so-and-so has been decreased for 2 years from so-and-so to so-and-so. In these 2 years, he would be entitled to get his annual pay like as usual. After 2 years, the basic pay would be given as earned. So he has been reduction up to pay for 2 years. Second part, your lordship, is B is with regard to the other person. I'm not reading that. So number 3, C is important. C is the other third point. Force number so-and-so, Constable Ramvilas have been suspended from service with immediate effect from so-and-so to so-and-so from 307 days, and they would be paid only the basic salary during these days. This is the finding of the commandant. We are not challenging this. Now, your lordship, what he has done, number 3 and 4 is the, they have number 4, your lordship. Therefore, the force number so-and-so constable may be given time to present before the authority his defense appeal against the proposed punishment. Whatever appeal the accused would make, it would be placed for consideration by the undersigned. So we have given a show cause notice so that we file our reply to the show cause notice. And after filing of the reply, the order was passed, that is page 71. Page 71.
No, this is what? This is a show cause reply, show cause notice.
Earlier was a show cause notice for enhancing the punishment. So the punishment that was given to me by the commandant that I have read, 2 years reduction in the scale of pay. Now he has proposed to increase the punishment. Therefore, he has given us a show cause notice. And against that, we have filed a reply.
No, but he does not disagree with the finding of the inquiry officer.
No, he did not. So I'll read that. The order is there, page 71. Page 71. I'll not read again the same allegations are put in the first pages. Page 73, your lordship, kindly take it.
So, Mr. Manan, is there any provision in the act or rule that suo motu punishment can?
No. That is why, that is what I am, on that day also I have shown your lordship that there is, the provision is only particularly to the higher authority for review. He has reviewed without giving suo motu. This is a suo motu review without even, he is an appellate authority. He could not, without filing an appeal, he has reviewed the punishment. Then after reviewing the punishment, we filed an appeal against the reviewed punishment. So it went to the next higher authority. And the reviewing authority did not review it, in fact. So it remained that. So this was basically my case. I argued on the last occasion. But the ground, I am just reading this, 2 things have come up. First, he has gone beyond his power. Number 2, he has not given any justification why he has reviewed it. That is why I'll just read one paragraph, paragraph 3 of page 73. Just one paragraph. Nothing is there. He just accepted the order and said that the punishment is not commensurate. How? After carefully, para 3, I'm just reading. So after carefully examining the departmental inquiry report and utilizing the so-and-so rules, the undersigned comes to the conclusion that the punishment given by the commandant so-and-so has been less compared to the seriousness of the crime. What crime? There was no crime committed. Force number so-and-so and constable so-and-so were served notice on so-and-so stating to give them punishment as per their offense. They were asked to reply to the notice 15 days and on both have handed over the so-called notice. The office of the undersigned got the confirmation of receipt of the so-called notice by the accused from so-and-so. The accused submitted a reply on so-and-so, which was sent to this office accordingly. The commandant so-and-so stated that they had no other documents to produce in support of connection with the case. On the basis of the reply submitted by the accused before issuing final orders on the matter, a detailed inquiry report was examined and then only the final order was pronounced. After minutely examining all the aspects related to the case, the undersigned finds the award of punishment was less compared to their offense. I have come to the conclusion that the offense committed by the accused were grave in nature and their act has brought a bad repute to the force. Therefore, I revise the punishment as follows. Now, 5 is the punishment given, awarded compulsory retirement with immediate effect. So he revised it without discussing anything. What is the crime? Wherefrom he has come to the conclusion that a crime has been committed. The inquiry officer found there is no crime. He has gone through it. There is nothing here. He has not applied his mind. Just in a way, he has reviewed it. Sorry. So this was the order passed. This is under challenge before your lordship. Subsequently, we filed an appeal and thereafter a review, and this has upheld this order. It was not, but the basis of the order is itself is not correct. That is what
DIG was the appellate authority.
He was the appellate authority. He reviewed it. So I'll now take your lordship to the rules. To the rules that
Which rules you are referring to?
CRPF rules. Lordship, I will take your lordship to just 2-3 rules. I have mentioned it in the my list of dates also. The rule, your lordship, first rule, your lordship will find rule 27. Rule 27. This rule I am showing because the power of giving punishment is in the hands of the commandant. So this rule 27, there is a chart. Your lordship will see serial number 3. These are the punishment to be inflicted by the, one is dismissal from removal from service, 2 is reduction in part time scale, and 3 is reduction in lower stage of time scale. All these with regard to constable, that is at the column 1, 2, 3, 4, 6. Column 6 is commandant. So in this case, your lordship, the commandant has correctly given, his power is that he has given the punishment of reduction in the time scale of 2 years. So that part has been answered. Now your lordship will kindly take up 27 C, 27C, and
Yes.
27C6, serial number 6. The same has, this has happened. If the commandant has himself held the inquiry, he shall record his findings and pass orders where he has power to do so. If the inquiry has been held by any officer other than the commandant, the officer conducting the inquiry shall forward his report together with the proceedings to the commandant, who shall record his findings and pass orders where he has power to do so. So this is the commandant's power. He has exercised the power. He has passed the order of reduction in the in 2 years of scale. Now your lordship will see triple C, CCC. This I am bringing because there was a criminal case also there, which I'll come later on. When a member of the force has been tried and acquitted by a criminal court, he shall not be punished departmentally under this rule on the same charge or on a similar charge upon the evidence cited in the criminal case, whether actually led or not, except with prior sanction of the Inspector General. So the criminal case was on the same charge of demand of extortion of money. And they ultimately, I'll come to that. We have been practically acquitted with this charge, Your Lordship. The only, there was a conviction initially by the trial court with regard to trespass, because I went to the person's house, but that was also later on, Your Lordship, it was converted to a fine of 1,000. And finally, this High Court, in a fine, that order is not here. I'll give a copy of the final order of this High Court. This was subsequent to filing of the writ petition. This High Court has given him on probation. So there was ultimately no conviction at all. So, Your Lordship, this is the basis of that. Now, Your Lordship will kindly turn to the appellate part. That Your Lordship will find at 28. Rule 28. Rule 28. Now, appeal, Your Lordship. Who is the appellate authority and whether how he should exercise? Every subordinate officer or personnel of any other rank below him against whom an order under serial number so-and-so table in Rule 27 that I have shown, section is passed, is entitled to prefer an appeal against by the special director, against such an order to the Director General if the original order was passed by the Special Director General or Additional Director General heading zone, and the Special Director General, Additional Director General heading zone if the original order was passed by the Inspector General, and to the Inspector General if the original order was passed by the Deputy Inspector General, and to the Deputy Inspector General if the original order was passed by the Commandant. Here the original order was passed by the Commandant. The Deputy Inspector General is the appellate authority. So he has reviewed it. He has no review power. That's what I'm going to show, Your Lordship. So Your Lordship will see serial then D. Every appeal, whether the appellant is still in force or not, shall be preferred through the Commandant and shall not be sent direct to the appellate authority. So what is happening, Your Lordship, when we file an appeal or review, we have to file it before the Commandant. And the Commandant on his own send it to the appellate authority or the review authority. So he does it. We do not do it directly. This I pointed out because why? Because we don't know where the appeal is going. So before filing of the appeal, our order has been reviewed. Then we filed an appeal. Then it went to the next higher authority. And then the review was also sent to the next higher authority. So this is why I'm saying. Now Your Lordship will kindly take up serial number 27 revision. This is where they are wrong. Revision 29, Rule 29. A member of the force whose appeal has been rejected by a competent authority may prefer petition for revision to the next superior authority. The power of revision may be exercised only when, in consequence of some material irregularity, there has been injustice or miscarriage of justice or fresh evidence is disclosed. The procedure described for appeal under Rule so-and-so shall apply mutandis to the petitions for revision. C, very important, the next superior authority, while passing orders on a revision petition, may at his discretion enhance punishment, provided that before enhancing the punishment, the accused shall be given an opportunity to show cause why his punishment should not be enhanced. Provided further that the order enhancing the punishment shall, for the purpose of appeal, be treated as an original order, except when the same has been passed by the government, in which case no further appeal shall lie, and an appeal against such an order shall lie to, these are the persons concerned. So what has happened? The reviewing authority is the higher authority to the appellate. That is stated here. He can review it on certain conditions by giving a show cause or by giving opportunity of being heard. So this is basically where they went wrong. Now, Your Lordship, with regard to the judgment of the criminal cases, I have already annexed. I'm not going into those. This is now my case basically hangs here. Now the question is, the appellate authority, without filing an appeal, number one, has reviewed the order and without giving any justification, neither application of mine, neither anything, no space, nothing has been stated. He said only one line, that it is not commensurate with the crime. Where is the first thing is there no crime? The only crime or whatever has been
Crime or
committed is
offense?
basically- No offense. My
No.
offense is that I visited the house of
Has
Rajiv
the,
Roy.
has the expression crime been used? It is offense.
It is offense, not a crime. But nothing, no offense. Only thing is that I went to visited the, maybe there is a, without being an, I am an uninvited guest. I am an uninvited guest. So I have been punished, given a punishment of 2 increments, sorry, 2 scale for 2 years. Now that has been enhanced to compulsory retirement, which is excessive. This is basically my points here. So that points also I have given the grounds raised by the petitioner in my list of dates. And now, Your Lordship, I'll just point out a few judgments. Already I have provided that. Again, I am just giving those judgments back to Your Lordship for Your Lordship's convenience. এইখন দিয়কচোন। এইকেইখন প্ৰথমতে দিয়ক, মই পাতি যাম। First judgment that I am relying, Your Lordship, is 1971, 1 SCC 622. This is with regard to the reviewing power without giving the, without his power, he has reviewed. That cannot be done on that ground. 71, 1 SCC. The last judgment in that list. Your Lordship. Lordship has got that.
No, these are all,
Now that bunch was given earlier to Your Lordship, so it has been, I think, stitched together.
all right.
There are 3 judgments, I think 4 judgments there. One is that AIR, oh sorry, 1971 1 SCC 662.
Yes.
662. And I am referring in paragraph 11 and 13. Para 11, Your Lordship will kindly see. I'll just read the small paragraph.
Yes.
No memorial or revision was filed either by the appellate or anyone else before the government, which was the appellate authority, which could entertain such a memorial or revision. Assuming that under rules of the
You're
government,
reading from para?
I'm reading para 11 of 1971 1 SCC.
Para 11 starts with under the rule, under this rule an appeal would lie before the government.
Oh,
You are referring to Makeshwar, not Srivastav.
yes, Mukesh sir, not Siva, I think, yes. Mukesh
Para
sir,
11?
not state of Bihar.
Yes. Reading from para 11.
I think it is paragraph 13 then, I think. No memorial or
Ah, yes,
revision.
para 13.
It
Yes.
is no memorial or revision, Lordship.
Hmm.
Here it is a different book actually I got.
All right. Hmm.
No memorial or revision was filed either by the appellant or anyone else before the government, which was the appellate authority, which could entertain such a memorial or revision. Assuming that under rules so the government could suo motu revise the order of Inspector General, an appeal having been filed before it, it could not so act. The fact that power of revision is conferred on the authority, this is important, conferred on the authority possessed of appellate power indicates that the power of revision is intended to be used when an appeal could not for some reason be filed and the appellate authority felt that the order was so unjust or unreasonable that it should act under its revisional power. So the 2 things have come up from this. That was not the case of the government before us, nor did the government say so in the impugn order. Therefore, there was no occasion for the government to revise the order passed by the Inspector General, exonerating the appellant of the charges preferred against him. So this is also a case where the review can be filed to a person who has given the review power. He may be in an appellate authority or whoever it is. This is the ground which I have taken. Because here, no power of review to the authority who has reviewed it without on a suo motu basis. So that is the only part I am relying, Your Lordship.
Yes.
Then Your Lordship will take up the next judgment, that is 2003, 8 SCC 9. Click on details.
Dev Singh. I have it. Dev Singh judgment.
2003, 8 SCC.
Dev Singh.
No, this is, Dev Singh, right. Dev Singh. It is there, right?
Which para?
Paragraph, your lordship, 6 and 7. This is on a factual matrix to an extent, but anyway, I'm reading that. Applying the said principle, your lordship has got that? Yes. Laid down by this court in cases noted herein above. We see that in this case, the appellant has been serving the respondent corporation for nearly 20 years with unblemished service before the present charge of misconduct was leveled against him. The charge itself shows that what was alleged against the appellant was of a misplacement of a file, and there is no allegation whatever that this file was either misplaced by the appellant deliberately or for any collateral consideration. A reading of the charge sheet shows that the misplacement alleged was not motivated by any ulterior consideration, and at the most could be an act of negligence consequent to which the appellant was unable to trace the file again. The disciplinary authority, while considering the quantum of punishment, came to the conclusion that the misconduct of the nature alleged against the appellant should be viewed very seriously to prevent such actions in future, whereby important and sensitive records could be lost or removed or destroyed by the employee under whose custody the records are kept. Therefore, he was of the opinion a deterrent punishment was called for, forgetting for a moment that no such allegation of misplacing of important or sensitive record was made in the instant case against the appellant, and what he was charged was of misplacement of a file importance or sensitiveness of which was not mentioned in the charge sheet. Therefore, in our opinion, the disciplinary authority was guided by certain facts which are not on record. Even otherwise, we are of the opinion that when the service bylaws applicable to the corporation under the service law so and so provide various minor punishments, we fail to appreciate why only maximum punishment available under the said laws should be awarded on the facts of the present case. We think the punishment of dismissal for a mere misplacement of file without any ulterior motive is too harsh, a punishment for which is totally disproportionate to the misconduct alleged, and the same certainly shocks out judicial conscience. I brought this to the point that here there was no misconduct proved. In fact, whatever has been proved is that I went to the house. There was no extortion, no money taken. So this part has not been proved. It was even, they have also not stated that it has been proved or something. Nothing has been stated. So the punishment of compulsory retirement on a fact which is alleged to have been that I visited a particular person's house, and from there on the motorbike, on the official motorbike. That is the only allegation. At best, you cannot, this is a punishment which is shockingly disproportionate. This is the reason I brought this. So next year, case your lordship will find it is 2008 3 SCC. 3 SCC 469. 469, para 19. I'll take up your lordship to para 19.
This judgment is not here. It is not in this compilation. Is it there? 2008 3 SCC.
This is 2008 3 SCC.
All right, it is there. Yes. Yes, it is there. Yes.
I'll read para 20 only. 19 again, the little bit of facts are there. So 20, the law point only. It is no doubt true that an appellate or a revisional authority is not required to give detailed reasons for agreeing or confirming an order passed by a lower forum. But in our view, in the interest of justice, the delinquent officer is entitled to know at least the mind of the appellate or revisional authority in dismissing his appeal or its revision. It is true that no detailed reasons are required to be given, but some brief reason should be indicated, even in an order affirming the views of the lower forum. Now the question is, Your Lordship, here, he has reviewed the punishment and enhanced it without giving any reason. In this case, this Honorable Supreme Court has stated that even if you agree, then also you give a little bit of a reason. Here he has totally reversed and he has not even given a single reason. That is one of the judgment, Your Lordship. Next, Your Lordship, find 2010 9 SCC 496. (496). Kranti Associates Private Limited. Here, paragraph 12. This is on the same footing with regard to the earlier judgment, giving reasons. Here, many judgments have been discussed by the Honorable Supreme Court. I'll read a few paragraphs, not all. Para 12, page 503. The necessity of giving reason by a body or authority in support of its decision came up for consideration before this court in several cases. Initially, this court recognized a sort of demarcation between administrative orders and quasi-judicial orders, but with the passage of time, the distinction between the two got blurred and thinned out and virtually reached a vanishing point in the judgment of the court on so-and-so versus so-and-so. Now, 14, Your Lordship. The expression speaking order was first coined by so-and-so and rather strange context. I will not read that, Your Lordship. Well, let me get into the... These are the judgments which have been referred by the Honorable Supreme Court. 24, 25, all Maneka Gandhi. Siemens in para 24, Siemens has been considered. 25, Maneka Gandhi has been considered. So these, there are many paragraphs, 12, 14, 15, 24, 28, 30, 32 and 47. All these paragraphs, Your Lordship, discussed about the judgments of various courts. 47 is the discussion and conclusion. So I will not read the earlier paragraphs. Summarizing the above discussion, this court holds, para 47. In India, the judicial trend is always been to record reasons, even in administrative decisions, if such decision affect anyone prejudicial. B, a quasi-judicial authority must record reasons in support of its conclusions. Insistence on recording of reason is meant to serve the wider principle of justice, and justice must not only be done, but it must also appear to be done as well. Recording reasons also operate as a valid restraint on any possible arbitrary exercise of judicial and quasi-judicial or even administrative. So after going through all those judgments, about 10 judgments by earlier Supreme Court earlier judgments, this court has framed these guidelines or framed these decisions, wherein it has come to summarizing that decision has to be done by giving reasons. So this is where I am again hitting the same point, that no reasons were given while enhancing the punishment. So this is the judgment on these. These are the two judgments on the on enhancing the punishment without giving any reasons. Now, Lordship, I'll take up the judgment. There's one judgment, Komaljit Singh versus Union of India. This is Punjab and Haryana High Court. I don't have a copy of that. That day, actually, I lost my copy. It is there. Punjab and Haryana. No, single. It was a single judge judgment. I'm not reading the judgment, Your Lordship. Paragraph 7, 8, and 9. Why I'm giving that single judge judgment? Because the facts are exactly the same in this case. There also, the commandant has given a punishment which was enhanced by the appellate authority reviewing it, wherein that court has in paragraph 7, 8, and 9 has clearly indicated that power is not existing to that authority, and therefore he cannot enhance it without being the reviewing authority, because it has hit Rule 29. He doesn't have a power under Rule 29 of the CRPF rules. this is the Punjab Haryana High Court judgment. Isn't it? It will also be in the private. Huh? Appel quiz. Take it.
So this is not exactly same on facts, quite
Yeah.
different.
It is rejected.
Similarity is, it's a CRPF official, that's all. Person.
Yeah,
In
but
the DO
yes,
inquiry,
but
there was an appeal preferred.
that was an appeal
How, these are two different, your argument is,
on
in
the
the
review.
absence of an appeal, you can't suo moto exercise review
Yes.
power.
Here it is not so. Here's an
Then we
appeal.
are saying it's exactly the same. on
But here he has enhanced the punishment in that case.
That's correct, but.
That
it
is the
different.
only part which is, but that is not suo moto. This is suo moto. Anyway, that just for the sake of the similarity of the facts I produced them. Anyway, next judgment that your lordship, on the last occasion, your lordship has just mentioned to me that if the person is, this order is set aside and he is reinstated, whether I'll be entitled to, when I argued that he will be entitled to back wages, lordship has specifically asked me to produce certain judgments on back wages. And the next three judgments that I am referring will be on the back wages, whether he is entitled. Oh, there is, oh, this, that is. So there are this judgment, first judgment that I am referring 2013. I'll just refer three judgments. 2013, 10 SCC. 324. 324. Back wages part.
2013,
2013, 10 SCC. 324. Para 22.
para 22.
20. The very idea of restoring an employee to the position which he held before dismissal or removal or termination of service implies that the employee will be put in the same position in which he would have been but for illegal action taken by the employee. The injury suffered by a person who is dismissed or removed or is otherwise terminated from service cannot easily be measured in terms of money. With the passing of an order which has the effect of severing the employer-employee relationship, the later source of incomes get dried up. Not only the employee concerned, but his entire family suffers grave adversities. They are deprived of the source of sustenance. The children are deprived of nutritious food and all opportunities of education and advancement in life. At times, the family has to borrow from the relatives and other acquaintances to avoid starvation. These sufferings continue till the competent adjudicatory forum decides on the legality of action taken by the employer. The reinstatement of such an employee, which is preceded by a finding of competent judicial, quasi-judicial body or court, that the action taken by the employer is ultra-vires the relevant statutory provisions or the principles of natural justice, entitles the employee to claim full back wages. If employer wants to deny back wages to the employee or contest his entitlement to get consequential benefits, then it is for him, her, to specifically plead and prove that during the intervening period, the employee was gainfully employed and was getting the same emoluments. The denial of back wages to an employee who has suffered due to illegal act of the employer would amount to indirectly punishing the employee concerned and rewarding the employer by relieving him of the obligation to pay back wages, including the emoluments. So this is one judgment on back wages. Next, your lordship will kindly take up 2016. 16S. 663. 2016. 16 SCC. 663.
That is the printout. Para
2016. 16 SCC, page 663, para 3. A very short judgment. Just page judgment. Para 3. Having given our thoughtful consideration to the controversy, we are satisfied that after the impugn order of retirement dated so and so was set aside, the appellant was entitled to all consequential benefits. The fault lied with the respondent in not having utilized the services of the appellant for a period from so and so to so and so. Had the appellant been allowed to continue in service, he would have readily discharged his duties. Having restrained him from rendering his services from so and so, the respondent cannot be allowed to press for self-serving plea of denying him wages for the period in question on the plea of principle of no work, no pay. So here the court has held that since you have not allowed me to work, so you cannot take the plea that no work, no wages, because I have been retired, compulsorily retired. Otherwise, I have been in duty. I would have done my duty. So I'm entitled to all the back. So this third is, your lordship, third judgment. This is 2013 that I'll have to give the book from here. 10 SCC 324. Eto kitab nai no, my dears. Oh no, sorry, 2015, sorry. 2015, 15 SCC 184.
15 SCC 1.
2015, 15 SCC 184.
Para.
Para 25. And 26. And 26 also. These two paragraphs. Just, your lordship, that book is not available. I'll give this book for book. I'll give this. I'll just read the paragraphs. For the reasons
You have
stated,
not given the book list.
I gave, but it is not available there. So I'll give this book. I'll just hand over this book. For the reasons stated supra, we have examined the case threadbare on the basis of the material placed on record and rival legal contentions ours on behalf of the parties. We hold that the finding of the inquiry officer on the charges is vitiated on account of non-compliance with the statutory rules and the principles of natural justice. In the absence of evidence, the order of reinstatement since full back wages is unjustified in law. At the best, the High Court should have made deduction of the amount of pension received by the appellant after awarding full back wages for the period in question. Not doing so, the order of the learned single judge and the division bench of the High Court are liable to be set aside with regard to non-grant of full back wages. Accordingly, we set aside the orders of the division bench imposing the penalty of reduction of one increment to the appellant for 1 year and restore and modify the order of the learned single judge with regard to award of reinstatement with full back wages for the period from the date of removal till the date the appellant attaining the age of superannuation on the basis of periodical revisions of salary to the appellant herein and deduct the pension amount from the back wages payable to the appellant. The same shall be paid to the appellant within 8 weeks.
So are you getting a pension?
No, I am not retired. Oh, sorry, I have been given compulsory retirement. So that I have challenged this before this honorable court. I have taken instructions on this regard, whether you have received the pension. I have not received the pension.
Why compulsory retirement means there will be pension?
Yes, they have communicated, but as of now, I have not received the pension. That is what I have been instructed by my client. And they have to do certain, I think, documentary things because it is here in Assam and he is a person from Bihar. I don't know, because of the gap, I don't know whether things are moving or not. But anyway, they have informed me about the pension and pensionary benefits, but it has not been received till today. That is my instruction. Secondly, your lordship, the last judgment, this is a new judgment. A to DTS. Take copy to DTS. This is a new judgment. This is dated 23rd of September 2022. September 2022. This is relying on the earlier judgment that I have already placed. before your lordship with regard to back wages. Para 12. It has relied on the judgment that I have already produced, the earlier two judgments. Well, in the more recent decision of so-and-so, this court highlighted the need to adopt restitutionary approach when a court has to consider whether to reinstate an employee, and if so, the extent to which back wages is to be ordered. The court ordered the very idea of restoring an employee to a position which he has held before dismissal or removal or termination of service implies that the employee will be put in the same position in which he would have been, but for the illegal action taken by the employee. The injury suffered by a person who is dismissed or removed or is otherwise terminated from service cannot easily be measured by the terms of money. With the passing of an order which has the effect of severing the employer-employee relationship, the latter source of income gets dried up. Not only the employee concerned, the entire family suffers grave adversities. They have deprived the source of sustenance. The children are deprived and opportunities of education, advancement of life. At times, the family has to borrow from the relatives and acquaintances to avoid starvation. This, your lordship, the same thing has been quoted here, which I have already read in the earlier 2013 judgment. And then, your lordship, the court has in para 15, the last paragraph, has given its judgment in this case. It has followed the judgment of 2013 10 SCC 324 that I have already given. In light of the above discussion, the impugned judgment is hereby set aside. The appellant workman shall be reinstated in service of the respondent within 6 weeks from today. He shall be entitled to the back wages for the period of 2 years immediately preceding so-and-so. The direction of the labor court and the single judge for continuity of service is restored. The respondent management is directed to pay the back wages as directed by this court in the current rates within 6 weeks. So basically, these are the grounds. I have given the back wages should be given because here the case is very clear that the authorities have wrongly given him compulsory retirement, which is very excessive, which shocks the conscience because there was no specific crime committed even in the criminal case as well as departmental inquiry. Nothing has been proved against him. Only proof is that he has visited the house of that person. He is an uninvited guest. For that, he has been given a small punishment, your lordship, reduction of 2
That
stages.
you accept that he had visited.
That I am accepting. I am not challenging that. Fine, something I have done may be wrong. You have given me punishment, I have accepted that. But the second part which you have done is totally against law, against your own rules. It is divorce the rules, beholds the law. Therefore, I am entitled to reinstatement with back wages. Obviously, the part which I have been reduction in rank will have to be taken into consideration, that they will always adjust. I am not against that. But otherwise, I am entitled. This is my basis of the whole case here. My submission.
My lord, there are 3 parts, my lord. One is, my lord, regarding the delay. First order was passed on, my lord, 15/7/09. Subsequently, that DIG order was of 22nd of October 2009, and they have approved the honorable court in 2018.
There is one just before my learned friend. I just missed out that. What has happened initially? The petitioner moved the writ petition before the Patna High Court. I have annexed the order. In the Patna High Court, the matter went for a period of time. Ultimately, the Patna High Court says that this court does not have the jurisdiction. You have to approach the appropriate forum, and thereafter we have come before this honorable. So that part has been taken care of. So just
Yes,
sorry for that.
well, and my lord, I will not go regarding the facts, my lord. Already my details already gone, my lord. There are 3 parts in the, my lord, 3 charges. Regarding the charge number 2 and 3, these are partly proved, my lord, that he have when house trespass was there, and regarding the use of the official motor vehicle, and regarding that and reputation of the CRPF authority. These 2 are proof. And he has not challenged the other earlier order also, my lord. He has accepted that. Now, my lord, regarding that part, my lord, and another thing is that, my lord, regarding the conviction part of the, my lord, criminal code, both the proceeding went parallelly, my lord, running parallelly, my lord. the judgment of the Malat session court, Malat, it was on Malat 28th of September 2011. When this order of DIG was 2009, then IG order is 2010, and DG Supreme order was the revision order was 14/2/2011. Subsequently, there are only 28th of September 2011 only. That was punishment of 1,000 regarding it is house trespass. It is proof, and conviction was there. Conviction because subsequently on the High Court, Honorable High Court, that was rejected. That is another thing. At that time, this order was not there. So, my lord, here I'll not go to the facts, my lord. Only, my lord, again, my lord, come to that rules, my lord. So, my lord, the authority who can give punishment is the commandant. Already, seniors stated, my lord, Rule 27. Commandant is the authority who can give punishment. Now, my lord, senior has skipped one thing, my lord, thankfully, my lord. Rule 28 is the, appellate authority, and appeal can be preferred to the DIG if the order is passed by the commandant. Last one is.
Mr. Parasar, say something new. I've already heard this.
Yes,
thing.
just I'm coming, my lord. Now, my lord, coming to my lord, please come to revision. Rule 29, this D, small d.
Where is this power to suo motu?
Yes, my lord. Yes, my lord, D, 29D. In my book, page 32, my lord. Revision is rule 29. 29, now, my lord, 29D.
D for
D.
Delhi.
My lord, yes. D. Top, my lord. The Director General or Special Director General or Additional Director General heading the zone or the Inspector General or the Deputy Inspector General may call for the records of award of punishment and confirm, enhance, modify or annual of the same or make or direct further investigation to be made before passing such order. My lord, here last one is or Deputy Inspector General may. So, my lord, in the hierarchy, my lord, above the commandant, next post is Deputy Inspector General. So he has the power to review suo motu. He can by giving, and if he is want to enhance it, he has to give notice. My lord, regarding appellate authority, yes, above the commandant, this Deputy Inspector General is the appellate authority. If any party agrees, then he may prefer appeal to the Deputy Inspector General through the commandant. Now, if there is a miscarriage of justice, if he feels that it is not proper, then it is as per rule, Deputy Inspector General have the power to suo motu review. Now, whose order he has to review, my lord? Immediately his junior order. So, my lord, his junior is commandant, nothing. Immediate junior is commandant, and the authority who can give punishment is commandant, not below him, my lord. So, my lord, if the rule maker has given this, my lord, rule 29D, Deputy Inspector General has the power to review by giving notice. So, to whose order he has to review, my lord? Obviously, his junior, that is the commandant's order, he has to review. If there is a miscarriage of justice or he thinks that, and accordingly in this present case, my lord, order was, my lord, of the commandant of 15/7/2009, though it is not in the, my lord, plain in record, my lord, the order was there, and accordingly, subsequently on notice 24/8/2009, notice page 64 already gone, my lord, that notice was given by the DIG for enhancement of the, my lord. And accordingly, only, my lord, one thing is that regarding that, my lord, detailed reason not given. Yes, my lord, that is in the record, my lord, I have to go by the record. Detailed reason is not given. Yes, he thinks fit and proper, it's enhanced. But there is no procedural lapse, my lord. He has given notice. And Lanet Senior has stated that he has no power. My lord, no, my lord. As 29D provide, my lord, Deputy Inspector General has the power. As he is the immediate senior to the commandant, my lord, he has given notice. And accordingly, he give reply to the so cause, and subsequently it was enhanced, my lord. Yes, but detailed reason not there. And subsequently, if for appeal before the IG, who is the my lord, senior to the DIG, IG enhanced my lord, it's my lord. Subsequently, file my lord, revision before the DG. DG order was same, my lord. It was rejected by the DG. So, my lord, procedural lapse, if my lord DSO said there is no power before the my lord, DIG, it is not there, my lord. He has the power. Only here, my lord, regarding my lord, regions, my lord, detailed region. He has given region, my lord. It is not like that he has not given reason. Reason given, but detail was not there.
So
And-
you are saying 29D, he
Yes.
has the power for suo motu review.
My lord, yes.
Any decision on that? Any decided case?
My lord, he has referred one case, my lord, that Kamaldeep Singh case, my lord, not by the Supreme Court, but that was my lord, single bench of Punjab Haryana. Subsequently, the division bench, my lord, where Union of India preferred appeal before, division bench set aside that order, my lord. I have the division.
Where is the judgment to the division?
My lord. Division bench order dated, my lord, 26th of August 2022. Last paragraph I have flag mark, my lord, last page.
Yes.
And my lord, here, my lord, in my affidavit, my lord, regarding the proceeding, my lord, the Superintendent of Police, my lord, Nalbari, my lord, caught him red-handed at that, my lord, house of the informant, my lord. Page 195 is the, my lord, statement of the, my lord, SP. My lord, this is the proceeding, my lord.
So SP was waiting there.
No, my lord, as far as that person called him, my lord, went to, and then SP along with the, my lord, team went, because they were in, my lord, civil dress, like demanding the money, and the informant don't know that who was the
Demanding money for what?
that is not come to the light, my lord, because what for what, my lord.
So are you saying when this person, including the petitioner, went to the house of the complainant,
Yes, my lord, that
they
person.
were demanding money, and then the person went and called the SP, he came there with everyone, still they were demanding money, and then when the
No, no,
SP entered, they caught him.
From the
How did it
house,
happen?
my lord, may see the page 195, that last page of the, my lord, affidavit, page 195 of the affidavit. Internal page 69, serial page 195 of the affidavit, my lord.
Yes.
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 SP Nalbari, my lord. On so and so date 10 September 2008, Rajiv Bora rang me in the evenings, and I was sitting in the Nalbari so and so stated that somebody followed him in Nalbari town and followed, supposed to come to his house to receive and demanded money. Then I called Ranjit Rai Bora, that informant, to police station Nalbari, and he told me about the details of the case. From him, learned to know that there some suspected personnel speaking in Hindi demanded for money for some day before and on that day. It was supposed to be handed over the demanded money to that suspected personnel at his residence. Then I made and planned to trap the suspected personnel. As per plan, I, along with Sub-Inspector so and so, Second Officer so and police staff went to the house of the Ranjit Rai Bora, and where I laid an ambush. After 30-40 minutes, two personnel entered the house of Rajiv Bora and sat in the drawing room. While they were negotiating about the amount, we entered in the house from rear side, in the civil dress, and from front side in uniform. Then we asked those personnel to show their identity. They refused to give their identity and started arguing with Sub-Inspector. Then I tried to. This is the malak. On hearing the shouted voice of the neighbor, Ranjit Bora came to his house, seeing the situation. I called some more police staff and police station. After some time, Osin Nalbari came to the spot. When Osin Nalbari came, suspected person, then we come to know that know the identity of the person. Then I made a call to the commandant so battalion. Could not get him malak. This is a malak fact. And Session Judge order, malak, order is at page 115 in the malak repetition, malak. And relevant portion of conviction is page 124.
Give me some marker.
Last page 124. The persons appellants are convicted under section 448, 34 IPC and sentence them to fine instead of SI for 1 month and fine 500 in default. I direct both the accused person to pay a fine of rupees 1,000 each for the offense so and so under section 448, 34 IPC in default, jail for 1 month. Conviction. And at that time of this conviction was that letter to the order of the DG Malad. Because order of the commandant DIG order of 22nd October 2009. This is of September conviction. At that time, this proceeding was parallelly, both the proceeding was going on, Malad. And he is acquitted only recently, Malad. This order is of Malad 2011. At that time, it was not there. Even at the time of DG order, Director General order, Malad, is of 14 February 2011. The Session Judge order of 28th of September 2011. So, my lord, all the process, my lord, this development proceeding has previously done, my lord.
And what do you have to say? He's saying even after compulsory retirement, he has not been paid anything.
That instruction, my lord, I have not, my lord,
Anyway-
today, my lord, I have
Anyway,
heard, my lord, that-
whatever, even if it is paid or not paid, that part will otherwise also he'll be entitled. If he is reinstated, if he is
No, no,
reinstated, then that will
You
be
don't want
deducted.
the court to go into that aspect.
Yeah, no, I'm just saying that it will be deducted from the whatever he's entitled as back, if it has been paid. But as per my instructions over phone, he said that I have not received. Though there was a communications were there that you are entitled to the whatever pension and other.
Actually, you have not placed 29D of the rules.
29D, your lordship, he has placed it. Fine, I will give a reply to that. I'll give a reply to that.
and
Because that part I wouldn't have gone through, but now I'll go through. Who has now since now
one thing is that, my lord, regarding that compulsory retirement, my lord,
But you should have placed 29D because you have relied on the judgment
yes,
of the Punjab Haryana High Court.
the Punjab Haryana High Court, what he
division-
said that
division में से avail, my lord.
whatever the case was with regard to appeal, it was enhanced in appeal. Here it has been reviewed. Then he put in this 29D. 29D has given power to all these persons.
Only one point, my lord. Sir, this is he is an employee of CRPF, my lord. This is not a normal, my lord, other employee, my lord. Regarding if, my lord, things, for instance, also, my lord, in that case also, my lord, his fitness since 2009 and last order is 2011, my lord. Now 2023, my lord. It's obviously not possible, my lord, to appoint such a person, my lord, after about, my lord, 12 years, and from the initial order of about 13 years, my lord. And regarding the, my lord, only one thing is the, my lord, explanation. Explanation was there. It's up to your lordship that it is, my lord, elaborate illustration or not, but explanation was there, my lord, regarding enhance, and there is no procedural lapse, my lord. He has the power. He given notice. He give the so cause reply. Then he enhanced, my lord. Subsequently, he file appeal, prefer appeal before the IG. IG dismiss it. Then revision before the DG. DG dismiss it. Now, after 3-4 years, he went to Patna. Then again, this High Court. A lapse of, my lord, 12-13 years.
Yes.
That's all.
So with regard to the 20, your lordship, 29D, that my learned friend has shown that there is a power of revision by the other authorities also. Now, your lordship, what has happened? Here I will read one provision 29B. Now that will have a different aspect. I'll come to that because initially I didn't want to go into that aspect also, but now I'll go into that. Now, your lordship will kindly take up 29B for a moment. B. I have read that. Again, I am reading it. The procedure prescribed for appeals under sub-rule C to G of Rule 28 shall apply mutatis mutandis to petitions for revisions. Now, here, your lordship, let us go back to 28. E, we'll go to E for a moment. An appeal which is not filed within 30 days of the date of original order, exclusive of the time taken to obtain copy of the order or record, shall be barred by limitation. Now, here, your lordship, what has happened? Now, this is a very unique point that I'll be raising because otherwise I wouldn't have gone into. Now I would like to go into that. Here there is a bar of appeal within 30 days. So that is also a bar in revision or reviewing within 30 days. Now either I file, it is with regard to the delinquent that you have to file an appeal within 30 days or
Mr. Manan, just a minute. Your argument in the beginning was, if I've understood correctly,
Yes,
that there is no power of suo motu review by an officer above the rank of the disciplinary authority, which is the commandant in this
29D,
case.
29,
That power is not there.
yes,
Only if some review or revision is filed,
yes.
then only the authority can
Yes.
review.
That is what my,
That was your
that was
argument.
my argument.
But to substantiate your argument, you have only placed 29A, B, and C before this court. But 29D seems to be saying just the reverse, that these officers can call for the record from the disciplinary authority and modify, enhance, whatever they want, if there are reasons given. So the first of all, 29D seems to be conferring the jurisdiction on the DIG to call for the records and on his own do it. The only requirement is he should serve a notice upon the official employee and give him an opportunity of being heard. That has been done here.
Within what period? Within what time?
So
That is
within
why
what-
I'm coming to this. The second part, that is why I'm coming to this on the second part. How and when a person, this will be reviewed, when and in what period and what time? What is the time limit? That is the question. That is why I'm coming to this. I have understood what your lordship has said. I would like to show the time period. For that, there is a judgment also. This has been sent in the mail, kindly mail to Saksu. There is a judgment of the division bench of Madras High Court considering this aspect. Yes, if you can review, that was a matter which was filed by the CRPF has filed the appeal before the division bench. And in that case, the division bench has clearly indicated, that is why I am coming to that, indicated that yes, if you do a suo motu revision, your revision should also follow the fact that 30 days limitation. The 30 days limitation you give for the delinquent employee, and in your case, you will do it whenever you want to. You cannot do that. That ground, it was set aside. So that is the judgment which has been sent in the mail. Just now. This is what I want to point out. Fine. They have come out with D. If he has the power, which I say he doesn't, then he doesn't have the authority to do it beyond 1 month, 30 days. And this is a case where he has done it in 2 months or more, I think. No, I have not counted it.
No.
But it was the order of
More than 1 month, only.
more than 1 month.
What judgment has been sent?
30.
You have it?
And with regard to the second part, your lordship, that he has alleged, that the delay part I have already stated. But another third point that he recently has given is that this person has been convicted or not. Now, two proceedings were going simultaneously. I agree to him. He's correct. Two proceedings were going simultaneously. But the question is, in this proceeding, let us take the departmental inquiry. Where is it? He has read it that he went to the so-and-so house, police came, this, that, caught them, red-handed, put in jail. He was in jail for 10 years. Doesn't make any sense until and unless you say that he has committed this offense. There is no proof that he has committed the offense. Yes, there is only one commission of offense which has been said is that he entered the house of the person. That is why the initial judgment of 1,000 punishment.
These proceedings are not connected with commission of offense. These are about misconduct.
Misconduct, fine. The misconduct, how, lordship, just tell me one thing. If you have not proved your misconduct, paragraph 7, that case. Paragraph 7.
So that we'll see.
Yes. What I wanted to point out, if that is not proved that you have demanded money or extortion, what offense you are talking about? Let us say, what is the offense I've committed?
No, Mr. Manan, there is a problem here. You must realize it. You are accepting the other punishment, original punishment.
Yes.
You are not accepting the second punishment.
Yes.
So you are not on the procedure of the inquiry.
Yes.
You are not on the
never said
procedure of
stated
the.
that.
All you are saying is the second punishment. Initially, you said your argument was that this was without jurisdiction.
Yes.
But now it appears that you are saying even if he had the power, it was beyond the prescribed period of limitation.
These are the, yes. And also I also stated, your lordship remembers that there was no justification given for enhancement of the punishment. There was not a single order passed in the
There is
review.
no reason given.
No reason, no reason. So that is a very important part, Your Lordship. I have given 3 judgments on that. Then Your Lordship, that was the second part. Third part, which he says that there were 2 proceedings going on. Fine. The criminal proceedings have, final order was subsequent to that. Fine, that is true. That is also,
So in this judgment, Hari Singh's case, which is the para you want to rely on?
para 7. 7,
Para 7.
yes. Yes.
So that is regarding filing of appeal, not suo moto exercise
No,
of
it's a review.
individual power. Mr. Majumdar, is there any limitation for suo moto exercise of?
My item number 20 is somewhat similar to my senior's case. Well, I have also taken that ground. If Lordship will kindly have para 7,
7.
it is very.
A plain reading of Rule 29, Your Lordship will show.
Yes.
7, in the last line, a plain reading of Rule 29.
Lordship, I'll read the whole paragraph. It is argued by the learned counsel for the appellants, that is the CRPF, that though Rule 29 refers to the procedure enumerated in sub-rule C to G of Rule 28 shall be followed for revisions, the same shall not be applicable in view of specific provision of Rule 29D, which does not prohibit the revisional authority to exercise suo moto power to revise the order. We are not convinced with the said reason. A plain reading of Rule 29B would show that the procedure contemplated under Rule 28E of relating to the filing of appeal within period of 30 days is also applicable for revision, as the said rule refers to petitions for revision. The said rule cannot
Right,
be
I have seen
restricted.
it. You have not argued it in the beginning. Now again, I have to give him a chance to reply. This was your only point, which you did not argue.
But this is a legal point, Your Lordship.
You should have argued it in the beginning. You are arguing it in reply. That means it's a new point made. We have to give him. I'll come back in 5 minutes.
But what he has said is correct, that criminal trial has ultimately culminated later on than this trial, but the departmental inquiry was there. The inquiry officer did not find any allegations. He proved with regard to demand of money or extortion. So that is not. Rest part, for that the minimum punishment that was given, one punishment that has been given. So that is acceptable to us. So I have not even challenged that. The second part is with regard to the suo moto part, Your Lordship has already pointed out. I pointed out that he doesn't have the power. He said that through the D, section 29D, he has the power to do it. Subsequent to procedure has been followed. So the procedure to be followed has been followed according to him. Yes, they have given us so cause, we have replied, and then he enhanced it. But while enhancing, he did not disclose any reasons for enhancement. He should have disclosed as per the judgments that I have shown. He should have disclosed. As a summing it up. Then Your Lordship, the second part with regard to the suo moto enhancement of punishment, that I have recently taken the legality of that, whether that should be done within a period of 1 month. Admittedly, it was done beyond a period of 1 month, about 40 days. He has also agreed to that. So if that is there, then that technical flaw is there. If Your Lordship accept it, not that is up to Your Lordship, but that technical flaw is there. And thirdly, Your Lordship, with regard to what he has stated, is that with regard to the crime, the offense that has been committed. The offense that has not been committed, that is already proved in the departmental inquiry. I am not going into the criminal trial because that is subsequent to that. So that will not hit here, because otherwise he has been ultimately acquitted in the criminal trial also. So that the final judgment of this honorable court, it is not annexed. I can give a copy of that also. So ultimately, there was no, Your Lordship, acquittal in that. And there was this punishment as of now. If Your Lordship takes D, 29D, considers that, then also the punishment of enhancement is harsh, totally harsh. It's beyond, it should not have been done for a particular offense which they have stated to have allegations. The 3 allegations, only 1 has been partially proved. 2 has been partially proved, they state, but technically not proved. One is that if you do not go for extortion, if you have not extorted money, if you have not demanded money, then there is no question of disrepute. The only thing that they can say, yes, the vehicle, government vehicle was used. That also was disproved, but only the motorcycle was found. Only that ground. And secondly, there is a fact that I have visited the house. That part also proved. On those two parts, whether a punishment of compulsory retirement enhancement is justified or not. That is your lordship will actually go through. On that ground, I have already given the judgments. And finally, your lordship, my learned friend has stated that with regard to that part, the last part, that within 30 days or not, which I have stated, this is a judgment already given to your lordship, that your lordship, if your lordship want to consider that, may not consider it, but on the other facts, with regard to the punishment given, that the amount of the punishment that has been given of compulsory retirement is highly excessive, and that should be set aside. That is basically on the facts of the case, on the facts of the departmental. And 29, your lordship, agreeing to what he said, I pointed out that it should be done within a period of 1 month, and it has been done beyond 1 month. That is, notice has been given on the 40th day.
Only,
What do you have to say on this judgment?
yes,
Madras
regarding
High
that, yes, as per record, on order was passed on 15/7/09, but subsequently notice was given on 24th of August at the 39th day, beyond the 1 month period, because as per 28.
So this is beyond 1 month.
Yes.
Yes, beyond 1 month.
And
And
therefore, it is-
yes, as per revision 29B, the procedure which is applicable to appeal is also applicable for revision as per 29B. So as per 28E, regarding the appeal, that is 30 days. That is, my lord.
that you agree.
My lord, yes. So I have
On the
to- I
ground
have
of
to go by the
limitation, you
record.
go.
I have to go by the record. That is on record, my lord. But regarding his contention regarding that as proof, not proof, these are, my lord, he has not challenged the order.
No, if the order is
regarding
hit by
enhancement?
limitation,
Yes.
then it goes, and if it goes, then the earlier order remains. That's all. What else is there to be decided here?
My lord, yes, my lord, regarding that point, my lord, yes, my lord,
We'll see.
That's it here.
my lord, may I
But
observe?
Mr. Y.S. Mandan, learned counsel appearing for the petitioner, also heard Mr. K.K. Parasar, learned CGC appearing for the respondents, arguments concluded, judgment reserved. You have the records? Give us the record.
My lord.
Give the record.
There is a small problem in the records. Most of them are in Hindi.
We'll manage
Only,
it.
my lord, that
What is
first
this?
order
What is
was
this?
not,
What is
my
this?
lord, there, but
What is this?
first order in
Hmm?
either in the petition
this?
or in the affidavit.
Affidavit we decide. What issue?
All translations could be either in the affidavit or in the petition, my lord. Okay. First one order not available in the same record.
All right. Hmm. So if the court agrees that the order was hit by limitation, then we'll not go into anything else. And you say that you are not controverting that.
But yes, I have to provide a record. my lord.
Okay. Yes, please take this.
Much of it.
Here.
Item 4. 4 months.
Well, the case in nutshell is these petitioners pursuant to an advertisement was appointed as Child Development Project Officer on contractual basis. So that was sometimes in 2010. Now they are continuing. Now, our prayer is, my lord, the government should consider in regularizing our services. That is in nutshell our case is. Now, having regard to some administrative exigency, the government of the day at that point of time made the appointment, but it has all the flavor of a regular appointment. In such a situation, my lord, the law is, starting from Uma Devi, my lord, there is no bar. In substance, that is.
But they were appointed against
Actually,
regular-
yes, my lord,
regular
sanction
vacancy.
post. The issue is like this, my lord. In Assam, there are 230 ICDS projects. Out of these 230 ICDS projects, only in respect of these 20, my lord, the appointment was made on contractual basis. As such, my lord, it's a project, well, the funding is 90% by the central government, 10% is by the state government.
And other ICDS child development, this is what? Child development.
Child
officer.
development, yes,
Project
project officer.
Others are on permanent job.
Otherwise, we do the same work, everything is same. In fact, my lord, if your lordship will kindly come to page 50 of the petition, there was a recommendation by the director, my lord, in 2015. Page 50, proposal with justification for creation. Well, the word creation was perhaps not required because already it is a sanctioned thing. And regularization of the contractual post of Child Development Project Officer under Social Welfare Department. With reference to the subject cited above as directed by you, I am submitting a proposal with justification for creation and regularization of contractual post of Child Development Project Officer under the Social Welfare Department, Assam. Social Welfare Department is one of the most important department implementing welfare schemes meant for women and child of the state under the ICDS. Presently, department has been implementing this scheme satisfactorily as per the guideline issued by the Ministry of Women and Child Development, Government of India. The posts required for implementation of these schemes have been created after fulfillment of the condition as per the guidelines. Now, this is important, my lord. Total number of sanctioned posts of Child Development Project Officer is 230. And out of 230 number of posts, 18 number of Child Development Project Officers were appointed as contractual Child Development Officer at the rate of rupees 20,000 per month as fixed pay in the month of January 2011 by dated 1/3/2011, and their services were extended up to February 2015 by latest dated so and so. The services carried out by both regular appointee Child Development Project Officer with scale of pay and contractual appointee with fixed pay are common, same, without any discrimination. Disparity of pay between these two set of Child Development Project Officer, it is afraid that it may lead to negligence of duty, thereby hampering to achieve the goal of Millennium Development as envisaged. The employees on contractual basis have been working with full satisfaction of all concerned. Regular employees and the contractual employees live in the same society and have to purchase essential commodities from the same market. Price of the goods for regular and contractual have no difference, but there is a vast difference in their salary against the equal nature of service provided by them. Hence, their demand to regularize their service appears to be justified. Regularization of the above-mentioned contractual employees working on fixed pay as proposed will induce quality human resource, which will not only improve the service delivery, but will create an impact on the service receiver, increasing community participation in the program, a cornerstone for effective implementation of the ICDS. It is to be mentioned about 100% of the above-mentioned contractual child development project officers have successfully completed job training course of the Child Development Project Officer at so and so, and some of them attended some other national level training courses which is related to implementation of ICDS scheme in the state. Even most of them were now performing NRC duties with full satisfaction to the Deputy Commissioner concerned. All contractual child development project officers will also perform election duties in both legislative assembly and parliamentary election sincerely and efficiently to the satisfaction of the returning officer and election observer of the concerned constituencies. All these employees have attained the training course on disaster management in the state and prepared a submitted proposal for disaster management. It is to be mentioned that most of the above mentioned employees are postgraduate in various subjects like sociology, education, social work, anthropology, economic studies. A regular employee with whom the concerned employee have to do equal duties, but regular employee get a great pay, house rent allowance, medical allowance, daily allowance, and other allowances as admissible as per ROP at present, while those contractual employees are discriminatorily being deprived. In view of above circumstances, and for greater interest of the public service, the state government is requested to take appropriate action for creation and regular. My lord, the expression creation may not be appropriate. The fact that, my lord, the ICDS scheme has been approved by the central government means it's sanctioned. Otherwise, my lord, state cannot do it of its own. Only thing is, my lord, having regard to some exigency in the administration, at that point of time, my lord, when the post was sanctioned by the government, it was appointed, for a 1-year basis. If your lordship would kindly come to the advertisement at page 29.
Mr. Just 1 minute. You see, the question of regularization of service will arise with reference to some posts which are in existence,
Yes.
permanent post,
Yes,
right?
yes, sanction
So,
post.
Sanction post.
Yes,
So first question is, are these 16 petitioners
yes,
who are apparently part of those 18 contractual employees?
yes.
Were their appointments made with regard to sanction
Yes,
post?
my lord.
Where is that material?
Yes. Kindly come to the advertisement, my lord.
Yes.
At page 29. Government of Assam Social Welfare Department invites application from intending eligible candidates who are citizens of India as defined in Article 5 to 9 of the Constitution with required qualification for engagement to the post of Child Development Project Officer on contract basis. The engagement will be purely temporary and on contractual basis for 1 year only on the following terms and conditions. Now, my lord, though the advertisement does not clearly state that the appointment would be against, my lord, sanction post, but my lord, unless an ICDS project is sanctioned by the central government.
All right, then is there any amendment in the writ petition that they
Yes,
were?
yes, I think.
Where is it?
It is there, my lord.
Which paragraph?
1 second. Yes, paragraph 5, my lord. 4 and 5. That it is respectfully stated that Child Development Project Officer is the key functionary of the schemes under the Integrated Child Development Service. The said officer is responsible for organization of services and also for administration and implementation of the ICDS scheme at the field level. In other, so and so. And now kindly see, it is pertinent to state here in the post of CDPO is gazetted post and central government bears 90% of the expenditure for payment of salary of all CDPO, rest 10% burn. The petitioners humbly state that as per the Social Welfare Recruitment Promotion Order, as amended from time to time, 60% of the post of CDPO in Social Welfare Department is required to be filled up by a direct recruitment and rest 40% by way of promotion from the feeder cadre. At present, there are 230 numbers of ICDS project in the state of Assam. Be that as it may, it is stated that in the year 2009-10, funds were received by the government of Assam for implementation of many new ICDS projects with a time frame failing which the fund would be lapsed. Therefore, though the direct recruitment to the cadre of CDPO is to be made through Public Service Commission, however, due to paucity of time and also considering exigency involved in it was decided by the government in the Social Welfare Department to appoint CDPOs on contractual basis as respondent number 2, commissioner and secretary, by advertisement dated, invited so and so, so and so. Well, unless though, my lord, there are, of course, my lord, we are not in a
So
position.
Mr.
to-
Chaudhary, let me cut the long matter short. Two options. Either you come up with, you means your junior can amend the pleadings and say that they were all appointed against permanent sanction post. If they do not deny it or they don't come up with a proper answer, the court can issue a mandamus. Or you submit a representation, we'll ask the government to consider it. Third option is not possible here.
No, my lord, we will file an additional affidavit.
Then you file it.
My lord, what I'll do, my lord, I'll explain the whole scheme.
Yes.
And my lord, this fact
So
finds
why
mentioned.
this has been mentioned is
Yes.
the other aspects are all cosmetic
No,
here.
I quite see,
The
my lord, that is a
core issue
condition
is-
precedent.
Yes,
That is a, no, I quite see that. If you lordship should kindly come to page 50 for a moment,
yes.
paragraph 2.
So this is, these are narratives which
No,
are
no, yes,
relevant.
it flows from
But
here.
these-
also.
these
No, no, I'll
can't
file,
be the
we'll file
basis
an
of a
additional
directive.
affidavit. Yes. Paragraph 2 for a moment, my lord. Total number of sanctioned post of child development project officer is 230. And out of 230 number of child so and so were appointed as so and so, so and so. So unless, my lord, the central government approves the scheme in the form of some sanctioned post, we cannot be appointed.
No, that is logical.
Yes.
But there
No,
is
no,
no
I'll come up
assertion.
with a straight cut, I mean, never.
Secondly, this is, which is the administrative department now?
Total welfare.
Or social welfare or social justice?
No, a state has not changed the nomenclature. It
Yes,
is
yes.
Social welfare.
New department has been created.
Bifurcated.
Yes, yes.
Bifurcated.
Oh, acha.
Social welfare department is bifurcated. One is social justice and other is women and child development.
Then we'll be under the second one.
Then you will have to implement the director.
Yes, new director. Yes, we'll do that, my lord. But will give us 1 week time, my lord.
All right, Mr. Ken Chaudhary and Senior Counsel for the
No,
petitioner, assisted by Mr. A. Patwari, Learned Counsel has appeared for the petitioner and seeks 2 weeks' time to bring on record additional pleading as well as an application for implement of the concerned director, implement of the director of the concerned ministry. So as to justify the prayer for issuance of a writ of mandamus. First up, Mr. T.C. Chutia, Learned Additional Senior Government Advocate Assam is present and does not have any objection. As such, this matter stands adjourned for 2 weeks.
2 weeks.
In the meantime, necessary pleadings stroke application be brought on record.
Diploma.
Obliged, my lord.
And I'm appearing on behalf of Ms. MD Vora. On the last occasion also, I think the petitioners were not present, my lord.
What is this matter about?
My lord, about the formation of a Hajj committee, my lord. Formation of a Hajj committee, my lord.
All right, you take down none appears for the writ petitioner. The petitioner's counsel was absent even on the previous occasion when this matter was called up before this court. Mr.
R.B. Goswami, my lord.
R.V. Goswami, Learned Counsel is present on behalf of the.
Miss MD Bora, my lord.
Huh?
Miss MD Bora. For the welfare of minorities and development, WMD department, my lord.
For the WMD department. First up, since the petitioner's counsel has remained absent on 2 consecutive dates, this court is of the opinion that the petitioner is not interested to pursue this matter before this court. As such, this writ petition stands dismissed for non-persecution. And what is the IA about?
Well, the same,
IA to file of IO stands disposed.
Obliged, my lord.
Item 6.
In this matter, my lord, we have prepared an affidavit, my lord. We have sent it for signature, my lord, yesterday. So, my lord, next week,
What is the matter, Mr.
My lord, the officer before the petition before my lord is a ACS officer of 2013. My lord, there was a departmental proceeding initiated against her in the year, my lord, 2020, my lord. Before that, there was a promotion exercise done and her batchmates and juniors have been promoted to the senior grade 2. She was not considered on the plea that there is a complaint case made against her and therein prosecution sanction has been given. My lord, on the date when the VPC met or even on the date when the officer, the orders of promotion were issued and even till date today, that has not seen any further progress, my lord. The complaint case. Now, my lord, I have instructions, my lord, that the complaint case has been made. The complainant had also filed an FIR, my lord. But there also, that case is also pending. Both the cases have been merged together. No charge sheets have been filed till now. Without a charge sheet, they have subsequently initiated a department proceeding against me. That is also, my lord, after the promotional exercise. So on the date of promotion, following KV Janaki Raman, my lord, there being no charge sheet, my case cannot be even kept under seal cover. My lord, I'll have to be promoted. That's my limited case, my lord.
All right, heard Mr. Yukenal, senior counsel appearing for the writ petitioner, also heard Mr. K.C. Kutia, additional senior government advocate Assam appearing for the state of Assam, who submits that the counter affidavit has been sent to the department for verification / signature and will be brought on record within a period of 1 week from today. As such, this matter be adjourned. In view of the urgency expressed by the petitioner's counsel and considering the prayer made by Mr. Chutia, this writ petition is directed to be posted again on 25/5/2023 as a fixed item. The counter affidavit of the department be positively filed on or before 22nd May 2023 by serving advance copy upon the petitioner's counsel.
Much obliged.
May I please counsel? Presently, I am holding the post as a insert secretary of Panigaon Panchayat Lordship in the district of Lakhimpur Lordship. And initially,
Can you pull the mic, please? Use it a little bit. Yes.
And initially, Lordship, we were approached before the Honorable High Court by filing WPC number 2358/5 Lordship, Annexa A, page number 14 Lordship.
So what is the case of the petitioner?
For regularization of our services, Lordship. Accordingly,
Regularization
Lordship.
of our means there is only one petitioner here.
Yes, Lordship, of my services, Lordship.
Who's
Except me.
petitioner or somebody else?
Yeah, no, Lordship,
Any
myself.
petitioner, all right.
Myself, Lordship. Initially, we together filed WPC number, Lordship, and this court has directed to the authority, Lordship, for consideration of our services, Lordship. Except me, other petitioner services already been regularized, Lordship. And Lordship, Annexa A, page number 14, Lordship. But Lordship, the authority initially did not consider our prayer being agreed. We have again filed contempt petition, Lordship, Annexa B, page number 16. My name has been enlisted at petitioner number 11, Lordship, in the said contempt petition, Lordship. But Lordship, subsequently, Lordship, authority has stated that we are not entitled to regularize our services, Lordship, and being aggrieved the same, Lordship. Again, we file another writ petition, Lordship, that is Annexa C, page number 11, Lordship, in WPC number 1486/15, Lordship. I am the petitioner number 11, Lordship, in that writ petition, Lordship. Accordingly, Lordship, this Honorable High Court has again directed.
Just a minute,
Lordship.
So petitioner was appointed when?
Lordship,
What is the original appointment order? Let us see.
no appointment order is there, Lordship, but engagement,
Engagement,
no appointment letter is there, Lordship, but Lordship, we were engaged by the authority, as a result of which, Lordship, our proposal has been forwarded in earlier occasion.
where is the engagement? Let us see.
Engagement letter is not mentioned, Lordship, but Lordship, Annexure I, Lordship, page number 60, Lordship. That is, Lordship, our services has been forwarded for approval of our, for regularization of our services. Annexure I, page number 16, Lordship. And another, Lordship, Annexure A is page number 56, Lordship. My name has been enlisted at serial number 1, Lordship, for regularization.
No, Mr. Saika, unless you tell the court what was the process through which you were engaged, when was it done, then against which post you are serving, regardless of who says what, a mandamus cannot be issued.
Yes, Lordship, can you?
This court is, the views of a director is not binding on this court.
Yes,
This
absolutely.
court will go by what is the law.
Lordship, Annexure A is page number 56, Lordship. Kindly be
Yes.
perused, Lordship. That is, Lordship, for a list of for regularization of our services, Lordship, and my name has been enlisted in serial number 1, Lordship. That is page number
You take your
57.
seat. What is his case? Can you tell me? He is not answering.
Lord, even I haven't had the time to go through the entire case. my lord.
Acha, you
All I-
also,
All I'm aware of is that,
you go through it after the judgment.
as per the last order, my lord,
Hmm.
we were required to produce the relevant record, my lord. That is the file number PDA 9/2001/53. We are yet to receive that document, my lord.
Then let him get the record. You are
Yes,
also not
Lordship.
prepared. Heard Mr. So-and-so for the petitioner, also heard Mr.
N.K. Devnath.
R.K. Devnath, Learned Counsel appearing for the
PNRD department.
PNRD department, Assam, who submits that 3 weeks further time is required to produce the records as called for by this court. Considering the nature of issue involved in this proceeding and the prayer made in the writ petition, perusal of the records will be necessary. As such, registry to list this matter. again
Lordship,
of-
earlier, Lordship, your Lordship ordered
The
at
next
14/9/2022, whoever directed as last opportunity,
Yes,
Lordship.
but you are not present. You are absent on the last date.
No, on 14/9/2022,
You are-
I
you are
am
absent.
present, Lordship.
Let us give him one opportunity.
Lordship,
After 4 weeks, as a fixed item. It will be listed as a fixed item.
Lordship.
Obliged.
And this writ petition is filed challenging the penalty imposed by the disciplinary authority. Then we preferred an appeal. Appeal was also rejected. List of this. List
How
of
much,
this.
how much time will be required?
Madam,
How much time will you need?
45 minutes.
So it will not be concluded today. This bench is not available for a second half, is it? Is it available, sir? Huh? All right, you start.
Madam, I'll start. If not, tomorrow I'll come here. And I have prepared a list of the other things. Basically the grounds on which I'm challenging, because I cannot challenge the adequacy of evidence, etc., etc. I don't reappreciation evidence in a writ petition where I'm invoking the writ jurisdiction. My lord, basically I'm challenging the whole punishment as well as the inquiry report on 3 grounds. One is, my lord, along with the list, along with the charge sheet, list of documents were given, list of witnesses were not given. Number 1. Number 2, my lord, the inquiry officer held that some of the 2 or 3 of the total 7 or 8 charges were proved, rest were not proved. Disciplinary authority disagreed. Thereafter, as per the regulation of the bank, my lord, I was given the opportunity of hearing as is required under the law.
What is it? Bipartite settlement?
It's a regulation, my lord. This disciplinary proceeding is governed by, they have got their regulation, my lord. State Bank of India Officer Service Rules. Now, under the rules as well as under the law, as the lordship is aware of that Punjab National Bank's case. If the disciplinary authority disagrees with the finding of the inquiry report, I have to be given an opportunity. Now, while giving me the opportunity, they have given to some extent the reasons on which they want to disagree. And thereafter, when I have submitted my reply, the disciplinary authority, before imposing me a punishment, must record its finding. No finding was recorded. Straightway, punishment was proposed and punishment was imposed. This is the second ground. This is directly hit by the judgment of the Punjab National Bank, I'll point out side the judgment. And thirdly, my lord, while before the inquiry officer, my lord, no witness was examined. So the documents on which they relied were not proved. The contents of the documents were not proved. Secondly, had they examined the witnesses, I would have got the opportunity of cross-examining those witnesses. That was also denied. So it's a clear case of violation of the principles of natural justice. There are 2 stages, your lordship is aware, there are 2 stages in a disciplinary proceeding. In the first part also, they have denied me the opportunity of hearing. So for the second part is concerned, my lord, by not recording any finding, the imposition of punishment was absolutely bad. And thirdly, my lord, possibly I need not have to go into that. Still, I am saying that it's similar, or maybe more. Guilt was more on the part of the, if any, on the part of the higher officers. A lesser punishment was imposed on them. So far as I am concerned, my lord, the punishment is penalty of reduction to a lower stage in the time scale of pay by 4 stages for 4 years in respect of 2 senior officers who were responsible for sanctioning the loan on the basis of fake LIC policies, my lord. For them, it was same punishment, penalty of reduction to a lower stage in the time scale of pay by 1 stage and for 1 year. This is the.
So you have already served the penalty.
I have served, but then once the punishment is set aside, my lord, I will get the benefit.
Yes.
And so far as the first point that the documents were not proved, I'll just point out from the repetition where I have taken the plea and from their reply that they have admitted that yes, they have not examined any witness to prove those documents, whereby the documents remained absolutely beyond the consideration of the inquiry officer. I'll just point out now. Page 12 of my writ petition.
Yes.
Page 12 of my writ petition, para 14 and 15, I have taken the plea, my lord. Reply para 14. Para 14, I am reading, my lord. That thereafter the DP was initiated against the petitioner and hearing of the said DP held on 17/8/2010, 28/8/2010, 30th September 2010, 8/11/2010, and 24/12/2010. It is stated that during the course of hearing of the DP, the authority produced number of documents and exhibited those documents without calling or examining any of the executor or maker of the documents before the DP. Moreover, the authority neither produced or examined any witness in support of the alleged charges. It is also stated that presenting officer of the DP was a law graduate having legally trained mind, and the fact was neither informed to the petitioner nor to the defense assistant by the authority during the DP. Next paragraph. That the petitioner begs to state that on 27th of January 2011, the DR submitted his defense brief to the inquiry authority stating inter alia that the DA has failed to frame distinct and definite charges on the basis of the allegations. The documents were produced and exhibited in DP were not supplied to the petitioner. The list of witnesses and their statements were also not supplied to the petitioner before start of DP, and the authority did not inform the petitioner on its DA that the PO is a law graduate, having legally trained mind, etc. The rest we can skip. Now, Lordship may kindly see what is there in the reply filed by them. This para 14 and 15 has been replied in para 6 of their affidavit in opposition. Page 3, my lord, running page possibly it will be 110, if I'm not wrong.
Page 110.
Should be my lord. Internal page 3 of the counter filed by the bank.
Yes.
Paragraph 6, I'm reading, my lord. That with regard to the statement made in para 14, 15, 16, and 17, the deponent begs to state that the disciplinary authority decided to hold an inquiry against the petitioner in accordance with the procedure prescribed under SBA Officer Service Regulation. An inquiry officer in this regard was also appointed. The delinquent was afforded with all opportunities to defend his case through a defense representative. The presenting officer relied relevant documents. These documents were admitted documents by the petitioner. The documents so relied by the presenting officer were marked as exhibits without any objection from the petitioner, as these documents were admitted documents. It is not the case of the petitioner documents placed in the departmental inquiry are not genuine. The delinquent officer was provided all opportunities to adduce his evidence and examine witnesses. After recording of statements, both the presenting officer and the defense representatives were allowed to place their respective arguments. Accordingly, both the presenting officer and defense representative submitted their written submission. The inquiry officer, on perusal of the material on record, including witnesses, submitted his inquiry report dated 3/2/2011 to the disciplinary authority. The inquiry officer held that the petitioner wrote various letters to LICI officer for assignment of policies, and these letters were handed over to the loan applicants instead of sending the same through registered post or by banker's messenger. The inquiry officer further held that the loan sanctioned by treating the LICI policy security can only be granted for, this has gone into the merit of the case. Fact remains, the allegation that I made in the petition, particular para 14 and 15 specifically, that you did not furnish me the list of witnesses is admitted, it's not denied. The fact that no witness was examined by them to prove their document was not denied. The fact that by not examining any witness, I was also denied the right to cross-examine those witnesses, which is a fundamental right as has been held by the Honorable Supreme Court. These are all admitted. Second aspect which I would like to point out to your Lordship, this paragraph 18 manner, where I have specifically made allegations about that the documents were not supplied. In fact, my documents, Lordship, may kindly turn to page 15, paragraph 18 for a moment. That the petitioner has a Lordship government. Para 18, that the petitioner submitted his statement of defense against the comments of the DA on report findings of the IA through proper channel, wide number, letter number, dated so issued by the chief managers, SBI Bongaigaon branch, stating inter alia that DA as biased neither considered the material facts which were brought up before the DP or the statements of defense submitted by DA. It is stated that the alleged charges against the petitioner was not proved by the authority which made those allegations. The authority neither produced nor examined any witness in support of the alleged charges leveled against the petitioner. It is also stated that several documents were produced in the DP for making exhibits, but those documents were not proved formally, and the admissibility of those documents were disputed. The authority miserably failed to produce and examine the executant maker of the documents in the DP, which resulted denial of reasonable opportunity to petitioner of having his say in the matter of defense. The PO was a law graduate having legally trained mind, and the fact that was not informed to the petitioner, thereby denying him to engage an advocate in his defense, which caused violation of natural justice and administrative fair play. It is also stated that the DP was conducted without produce and examining the witnesses, and thus denied the petitioner an opportunity to cross-examine those witnesses to rebut the allegations. The whole thing was therefore projected, designed fully to deprive the petitioner and for establishment of the charges illegally and arbitrarily. Therefore, the alleged charges have been failed in lack of, and this sentence is not correct, but then fact remains that I have specifically alleged and these things are not denied now. Now, the second thing that I would like to point out is, my lord, I'll take your lordship straightway to the page 66, my lord. Page 66 is the 66. Is the notice whereby, my lord, the disciplinary authority has informed me that they are disagreeing with the findings recorded by the inquiry officer. And by this, they have given notice to me to represent my lord. 17th, page 66, letter dated 17/3/2011. With reference to our letter number so and letter number so dated so on the captioned subject, I forward herewith a copy of inquiry report findings submitted by the inquiry authority along with the disciplinary authorities comments on the said report findings as stated below for your information. Allegation number 1, inquiry authorities findings. Allegation number 1 is not proved. DA's disciplinary authorities comments manner. I agree with the findings, so this goes. Number 1 was not proved, and according to the inquiry officer, and the authority has accepted that. Number 2, my lord, allegation number 2 is proved. I agree, then it remains. Number 3, allegation number 3 is not proved. I disagree with the findings of the IA. Anxiety for achieving ambitious business budgets cannot be a ground for violation of the bank's laid down system and procedure. Similarly, policy guidelines for aggressive marketing of schemes like loans against LIC policies cannot be accepted as a reason for violating the bank's laid down systems and procedures. I therefore hold that the allegation is proved. Allegation number 4 is also not proved according to the inquiry officer. Now the disciplinary authority says we disagree, and then it says I disagree with the findings of the IA. Allegation number 4 is distinct from allegation number 2 and cannot be construed as being identical with the latter allegation. The IA has correctly observed under allegation number 4 that clear instructions issued by the bank to mitigate the risk factor involved in verification of LIC policies and assignment thereof were not followed. I therefore hold this allegation is proved. Similarly, allegation number 5 is proved. I agree. So 5 also remains. So far as 6 is concerned, it was not proved by the inquiry officer, and the authority has disagreed, saying that with the findings of the IA, the CSO signed the control returns to regional office in respect of these loans, even though he was aware that he had not accorded sanction in relative loan application proposal form. In such circumstances, it was incumbent upon him to have found out who sanctioned these loans. The preponderance of probability is clear that in fact he knew who had sanctioned these loans. Hence, I hold this allegation is proved. Then allegation number 7 is not proved by the inquiry officer. And they disagree, and they say, I disagree with the findings of the IA. In view of what has been stated by me under allegation number 6, I hold that this allegation is proved. And then so far as 8 is concerned, it is proved, so the authority has agreed. So Lordship will see that as far as allegation number 1 is concerned, it goes because it was held by the inquiry officer to be not proved and the authority has agreed. 2 remains because 2 was held to have been proved by the inquiry officer himself. So far as 3, 4, 6, and 7 are concerned, these allegations were held by the inquiry officer to be not proved. Authority has disagreed. And by this, I was given the opportunity of hearing, which is required under the law. Lordship may kindly see the next paragraph at page 67. If you desire, page 67, if you desire, you may return your representation submission within 7 days from the date of receipt of this letter and the inquiry report come findings. Please note that no extension of time is permissible in this regard. In the meantime, please return the enclosed duplicate copy of this letter duly acknowledged by you under your full signature with date in token of having received the original along with the enclosures. Now, next page 68 is the forwarding letter by me, whereby from page 69 to my lord, page 678, I have given detailed reply to the grounds on which the disciplinary authority seeks to disagree with the findings of the inquiry officer, madam. Each charge I have dealt separately. I'm right now, madam, I'm not reading it because I'm just pointing out what they have done thereafter. Just next page, page 79, Lordship may kindly see. This is the proposal, and before proposing to impose a punishment, they should have recorded a finding. My submissions, my lord, they should have recorded a finding that yes, we are not satisfied with your reply, and we are recording a finding that charges are proved. Lordship will kindly see what they have done. Please refer to the charge sheet dated so-and-so served on you, and the inquiry officer's report dated 3/2/2011, and subsequent proceedings in the inquiry upon due, this is the only line, my lord, upon due consideration of the records of the inquiry, I propose to impose major penalty of reduction to a lower stage in the time scale of pay by 4 stages for a period of 4 years, with further directions that the officer will not return increments to pay during the period of such reduction, and on the expiry of such period, the reduction will have the effect of postponing the future increments of his pay, as provided under Rule 67(1) of the State Bank of India Officer Service Rules. You are hereby called upon to appear before the undersigned on so-and-so and so-and-so for personal hearing. Thereafter, I submitted my reply, and then this is my reply at page 80, my lord.
So you were given a personal hearing.
Personal hearing after this. My submission is slightly different. What I'm submitting is, my lord, personal hearing is a completely different thing. Once you give me an opportunity of hearing after you have decided to disagree with the findings of the inquiry officer, and I submitted my reply, you have the further responsibility of recording your finding that after considering my reply, you are not satisfied with my reply. So you are holding that these charges are proved.
That requirement is under the law.
Under the law, my lord.
Why do you say so? Is there any judgment on that?
Specific judgment, my lord. Specific judgment, specific prayer I'll read. If your lordship desires right now, I'll read with me. Right. This is Punjab National Bank, my lord, versus Kunj Bihari Misra, 1998, 7 SCC. 1998, 7 SCC, page 84. 84. 84. 1998, volume 7, SCC, page 84. Madam, there are quite 2-3 paragraphs which are relevant. I'll read those. For this matter, I'm reading paragraph 19 of the judgment, madam, page 97. First, got, madam?
Yes.
Para 19, madam.
Yes.
The result of the aforesaid discussion would be that, incidentally, the provision of regulation 7(2) is perimeter with the application, absolutely word by word, my lord. The result of the aforesaid discussion would be that the principles of natural justice have to be read into regulation 7(2). As a result thereof, when the disciplinary authority disagrees with the inquiry authority on any article of charge, then before it records its own findings on such charge, this is the sentence. Before it records its own findings on such charge, it must record its tentative reasons for such disagreement and give to the delinquent officer an opportunity to represent before it records its findings. So two things are there, my lord. Let me complete the sentence, my lord.
Yes.
The report of the inquiry officer containing its findings will have to be conveyed, and the delinquent officer will have an opportunity to persuade the disciplinary authority to accept the favorable conclusion of the inquiry officer. The principles of natural justice, as we have already observed, require the authority which has to take a final decision and can impose a penalty to give an opportunity to the officer charged of misconduct to file a representation before the disciplinary authority records its finding on the charges framed against the officer. In this case, what has happened, my lord? The inquiry officer has given the finding in my favor. You have proposed to differ with the finding of the inquiry officer. And you have given me an opportunity under rule of your rules only, that kindly represent. I have replied. Now, neither you have considered my reply against each of those charges, nor you have recorded any finding that, yes, I am not satisfied with the reply you have given. So I am recording a finding that this charge stands proved. And incidentally, as I have pointed out, my lord, in this case, my lord, the Honorable Supreme Court was dealing with page 90, Lordship, may I kindly see.
Page 90.
90, my lord. It's part of paragraph 10. Page 90, in the middle, Lordship will find what action has to be taken. My lord, one sentence starting with the words, what action has to be taken. Lordship has got, my lord. In the middle, page 90, my lord. What action has to be taken on the submission of the inquiry report is provided by Regulation 7. That your Lordship has got, my lord. Page 90, my lord.
Of the paper book of the writ petition.
No, my lord, I'm reading the judgment, my lord. From the judgment, I want to show that the provisions which were being considered by the Honorable Supreme Court are the same in our case also.
All right, all right. Yes.
Page 90, somewhere in the middle, my lord, Lordship will find what action has to be taken. Lordship has got, my lord?
Yes.
What action has to be taken on the submission of the inquiry report is provided by Regulation 7, which reads as under. Action on the inquiry report. The disciplinary authority, if it is not itself the inquiry authority, may, for reasons to be recorded by it in writing, remit the case to the inquiry authority for fresh or further inquiry and report, and the inquiry authority shall thereupon proceed to hold the further inquiry according to the provisions of Regulation 6 as far as may be. Now is important. 2, my lord. The disciplinary authority shall, if it disagrees with the findings of the inquiring authority on an article of charge, record its reasons for such disagreement and record its own findings on such charge if the evidence on record is sufficient for the purpose. Now, this is what was being interpreted by the Honorable Supreme Court, and in our case,
Yes.
My Lordship, may kindly see Rule 68.3.1.2. That your Lordship possibly find at page 45. But at the bottom, the page number is given, my lord.
Page 45.
Page 45. And regulation. And on top of that page 45, Lordship will get 68.3.1.2.
No, there is a mismatch, looks like. 68.
Because
68 is in page 38. No.
that's it.
Mr. Majumdar, can you just have a look?
No,
at
no,
it?
I'll just find
It's
out
not
for you.
telling.
But yes. Take one, two, see. They bunched her up. I'm sorry, man. That's what- I'm sorry, man.
So when do you want this matter to be fixed, Mr. Majumdar? Mr. Dasgupta?
Matter has been pending. Can it be taken up tomorrow? And I want to complete.
Tomorrow is not possible. Tomorrow we can't, but now that the hearing has commenced, we can take it on 18th of May. Heard Mr. D. Majumdar, Learned Senior Counsel, assisted by Mr. S. Biswas, Learned Counsel for the petition. Also heard Mr. A. Dasgupta, Learned Senior Counsel, assisted by Ms. B. Das, Counsel appearing for the respondents. Heard in part, let this matter be listed again on 18th. Or should we have it on 23rd May? It's a full hearing day.
23rd.
18 again, there is a division. Let's have it on 18th. Yes, 18/5.
18, man.
18/5/2023 for further hearing. Yes,
Or I've given the rule, man.
I take liberty to mention item number 15. Yes.
This, not today, my lord. Some date may be fixed because then constable my lord dismissed from service.
Yes, when do you want it? When
18th
would you want it?
18th next week. It is a fixed item.
Yes,
Otherwise.
18th. So we'll continue.
My lord, I have handed over the rule and the exact provision, my lord, tick mark.
You want to keep this book with you today, this regulation?
No, no, my lord, I have got my extra. It's for the on the court, my
All
lord.
right. So it's time.
My
We'll rise then.